morning, and welcome to this webinar, How to Apply for an H-1B Visa. Today, we're going to spend some time talking about H-1B visas. This is a very relevant visa since the H-1B cap season has just started. So a few things before we get started with the webinar. Scott Legal is a full-service immigration firm that processes many H-1B visas. Our firm founder, Ian Scott himself, has been on an H-1B visa and is happy to answer questions about his experience. We will continue doing our webinar series, doing at least 2 webinars a month on different topics. We have many scheduled webinars coming up on a variety of topics. If you visit our website, we have a list on there where you can sign up. After the webinar, we will send you this PowerPoint presentation, an H-1B comprehensive visa guide, and a link to where you can sign up for additional webinars. I will be the panelist today. My name is Kelly LeGrand-Wiener, and I'm the managing attorney at Scott Legal, and I've processed many H-1B visas. If you have questions throughout the presentation, please just add the information to the chat box or the Q&A, and we will attempt to make time for questions at the end of the presentation. Finally, this webinar is being recorded and will be made available on demand. So now we will get started. So what is an H-1B visa? What are the H-1B visa requirements? So to qualify for an H-1B visa, the worker must have a U.S. bachelor's degree or higher in a specific specialty. They may have a foreign degree that is equivalent to a U.S. bachelor's degree or higher in a specific specialty. They may have an unrestricted state license, registration, or certification that authorizes them to fully practice the specialty occupation, or they may have education, training, or progressively responsible work experience in the specialty that is found to be equivalent to a U.S. bachelor's degree or higher. So another requirement, the H-1B worker must have a job offer from a U.S. employer in a specialty occupation. A specialty occupation requires theoretical and practical application of a body of specialized knowledge and attainment of a bachelor's degree or higher in the specific specialty as a minimum requirement for entry into the occupation. So to prove that a position is a specialty occupation, you need to show one of these 4 elements below. So either the bachelor's degree or higher is normally the minimum requirement for entry into the particular position. You can look at things like the Bureau of Labor Statistics or the Occupational Outlook Handbook from the Department of Labor, which talk about what degrees are required for which occupations. You may show that the degree requirement is common in the industry and parallel positions among similar organizations, or that the position is so complex and unique that it can only be performed by someone who has obtained a degree. You could show the employer normally requires a degree or its equivalent for this position. So looking back, if it's a job where the employer has hired many of the same, for many of the same job, like multiple accountants, and they can show a history of requiring a specific degree, this can be used. Or that the nature of the duties are so specialized and complex that the knowledge required to perform the duties is associated with the attainment of a bachelor's degree or higher. All right, so when can you apply for an H-1B visa and what is the lottery? So there's a limited number of new H-1B petitions that can be adjudicated each year. This is referred to as the H-1B cap, and there's 85,000 slots each year for new H-1B applications. 65,000 of those slots are for what's called the regular cap. And then 20,000 are reserved for U.S. advanced degree petitions, so people that have a U.S. master's degree or higher. And then the 65,000 are for people who have either a bachelor's degree or higher. If you're filing an H-1B change of employer petition or an extension petition, let's say you've already been counted in the cap and you want to change your employer, or you've been with one employer for 3 years and they're extending, you're not subject to the H-1B cap. These petitions can be filed at any time. However, for the lottery, for new H-1B petitions where you've never received an H-1B before, those can only be filed during a specific period of time. So because there's more than 85,000 registrations submitted every year, only 85,000 slots, USCIS runs a lottery, and that happens every year in March. So last year, there were 308,613 registrations submitted for these 85,000 slots. So it's quite, many more applicants than slots available. The way the H-1B lottery works is there's a computer-generated random selection process to select the petitions. And in 2020, the lottery became electronic, and we'll talk more about that on the next slide. Another thing to just keep in mind is there are H-1B cap exempt employers. So these are employers that their H-1Bs are not counted toward the $85,000 cap, and they can file to sponsor an H-1B employee at any time. So institutions of higher education or related or affiliated nonprofit entities, or a nonprofit organization or governmental research organization, these entities are not constrained by the cap. All right, so what is the H-1B application process? So the registration period for this year runs from March 1st to March 18th, 2022. It was just this week that employers were allowed to make a new USCIS account as H-1B registrants. So once that account is made, excuse me, the H-1B employer, after they make their online account, then their employer or the attorney can prepare an H-1B registration, and then they can submit that registration. And the fee for the H-1B registration is $10 for each registration, which is for one single beneficiary. So if you're submitting registrations for 20 different beneficiaries, there's going to be a $10 fee for each one. USCIS will then run the lottery, and applicants should be notified by March 31st. And then if you are selected in the lottery, your petition needs to be filed within 90 days. So if it's selected by March 31st, then you have between April 1st and June 30th to file your petition. It is also possible that if they select a number of registrations and they don't end up meeting the number that they need, they may run a second or third lottery. And that did happen last year, where additional lotteries were run, and new people were able to be given that 90-day filing window to submit their H-1B petition. So if you are selected in the lottery, the application process involves first preparing a labor condition application with the Department of Labor. And these take about 7 business days to be issued by the Department of Labor. Then you need to prepare your H-1B petition, which will consist of USCIS filing fee, filing forms, the fees, and supporting documents showing that the job is a specialty occupation and that the worker has the required degree or equivalent experience or license in that specialty occupation. When you file your H-1B petition, you have an option to file either as a change of status or for consular processing. If you're filing as a change of status, let's say you're in the United States as a student, you're on your OPT, and you don't want to leave. You want to have this uninterrupted time in the United States. So then you would likely file for a change of status. And then if your petition is selected and approved, you would automatically change to H-1B status as of October 1st of 2022. If you're doing consular processing, then your status would not automatically change. If you get approved, then you would need to leave the United States, go to a consulate, get an H-1B visa stamp in your passport, and then re-enter when you're ready. Sometimes people, for example, on STEM OPT, may choose the consular processing option because they're at the beginning of their STEM OPT and they'd like to kind of go for the cap to see if they get selected, because it can take a while. But then their H-1B is approved and they have the approval notice, but they won't automatically change to H-1B status. They can go in the future when their STEM OPT is closer to expiration and get the H-1B at that time. So thinking about family considerations, an H-1B employee's family can come with them to the United States. The spouse and unmarried children who are under 21 can get H-4 dependent visas. The children and the spouse can study in the United States. The spouse generally cannot work in the United States. There's limited exceptions to this. For example, if the H-1B worker is at a certain point in the green card process, there's an I-140 approved or something like that, sometimes the H-4 spouse is able to work, but it's very limited. who can pay for the H-1B legal and government filing fees? So for legal fees, attorney's fees related to the H-1B, generally an H-1B employer cannot require that the employee pay for these fees or reimburse for attorney's fees associated with the H-1B. And this includes, kind of prohibition on side agreements to pay back the fees. It's also a general best practice. The employer cannot take the fees out of the employee's paycheck. There are limited exceptions to this. So for example, if the person makes a very high wage and deducting the fees doesn't reduce that wage below the required wage, which means either the actual wage being paid to the applicant or the prevailing wage, whichever is higher. So if the taking the fees out doesn't reduce that employee's paycheck below what's permitted, then sometimes it's permitted. However, it is a best practice for employers to pay for the H-1B fees, since there's some dispute in the statutes about what's actually permitted. One exception to this that's clear is that the H-1B employee can pay for the legal fees for dependent applications. So the employer may choose to pay for those fees, but there's no requirement that they do. And the H-1B employee is not prohibited from paying those fees. For the filing fees for the H-1B, there are several filing fees. The I-129 filing fee, there's an anti-fraud filing fee and an ACWIA fee. There's also an optional premium processing fee. The employer must pay the anti-fraud and the ACWIA fees. There's no debate there. They must pay those fees. One exception is that the employee can pay the premium processing fee, since this is optional. So if the employer is not interested in kind of doing a faster filing, but they're open to the employee paying, then the employee can pay for that premium processing fee of $2,500. Current H-1B adjudication trends. So starting in 2016, it became more difficult to obtain H-1B approvals, and there was a largely increasing rate of requests for evidence. There was also the implementation of the Buy American, Hire American executive order, which was often cited as a reason for higher rates of H-1B denials. This executive order was under the previous administration and has now been revoked. There were additionally a lot of pending regulations promulgated by the previous administration that have been blocked by litigation or delayed or have now been withdrawn. So there were several things, potential rules redefining specialty occupation, limiting third-party placements, changing the definition of employer-employee relationship, changing the lottery system so it's based on wages. And that last one, the wages, that wage-based selection process rule was withdrawn by the current administration after the rule was vacated by a court challenge. So for many of these things that potentially could have made it more difficult to obtain an H-1B, they've been withdrawn or no longer in process. And there's been positive news in that the initial H-1B approval rate rose to 97.3% in 2021, and denial rates dropped from 13% in 2020 to 4% in 2021. So the rates kind of, that dipped very significantly between, 2016 and 2020 are now climbing again. So what happens if you lose your H-1B job? So if the job is terminated, either because you've left the job, you've resigned, or you've been laid off from the job, then the first thing you should do is check your I-94. Let's say that your I-94 is still valid for a year. In that case, you would have a 60-day grace period to remain in the United States. During that time, you can, either make plans to depart the US, you can look for a new job and have your new employer file a change in employer petition for a new H-1B, or if you need more time or on have a spouse or family member here, you could potentially change to a dependent status. For example, if your spouse is studying and obtains an F1 student visa, you could change to an F2 dependent student visa. One thing to make sure of is your I-94, because let's say your I-94, rather than expiring in a year, expires in a month. So then you wouldn't have the full 60 days on your grace period. Your grace period would end with your I-94 end date. So at that point, you would only have a 30-day grace period to either depart or change to another status or find a new H-1B job. So what are the H-1B grace periods? There's two grace periods that are relevant for H-1B visa holders. So one is the 60-day grace period that we just discussed. This is when your employment ends unexpectedly, and it allows you that time to kind of make plans, get a new job, or leave the United States or get a new status. You are not permitted to work during this grace period, but you are permitted to change your status or to change employers to a new H-1B employer. There's also a 10-day grace period that is relevant for H-1B visa holders. During the 10-day grace periods, you're not permitted to work. However, they can be granted on 10 days on either side of your approval notice. So 10 days before the validity period begins and 10 days before the validity period ends, or after the validity period ends, to allow you to enter the United States right before your job starts and to give you a few days to depart when your job ends. The 10-day grace period is not always given, particularly if you're entering, you're coming into the United States with your H-1B visa stamp. You should always check your I-94 because there are times when the Customs and Border Patrol officers, will not give you that 10 days. And you want to, you need to be directed by what's on your I-94. So if you want the 10 days of the grace period, you can go back and ask them to change the I-94, but you shouldn't just assume you can still take the 10 days. You should be guided by what's on your I-94. So how many times can you renew the H-1B visa? You can be granted the visa for up to 6 years in 3-year increments. So, if you're selected in the CAP, you'll change status to H-1B on October 1st, and then, the approval will be good for 3 years from that date. And then you can extend for another 3 years. Only time spent in the US counts towards the 6 years. So sometimes you can file an H-1B recapture petition to get additional time. For example, let's say you're here on the H-1B, but every year you spend, 3 weeks on vacation out of the country. What you can do is you can save your travel history from the I-94 website, your plane tickets, your itineraries, receipts that you have from when you were out of the country, and then you can submit an H-1B recapture petition with that evidence to kind of get back those several weeks that you were out of the United States to kind of extend that H-1B time if you need to. There's also certain exceptions that allow for extensions beyond 6 years for applicants who are in the green card process. So the first is the lengthy adjudication delay. This is a 1-year extension that's available if 365 days have passed since either the filing of a labor certification with the Department of Labor or the filing of an immigrant visa petition, an I-140 with USCIS. So it can give you that additional time that you need. There's also a per country limit exemption. So if you have an approved I-140, but the applicant's not yet able to file for a green card because there's limits on immigrant visa availability, this is especially relevant for Indian and Chinese nationals, then you can get a 3-year extension on your H-1B just by showing the visa bulletin and showing that there's not an immigrant visa available for you at this time. So do you need an H-1B to apply for a green card? It's very common that people will come and ask whether or not they need to go to the step of an H-1B before getting a green card. And you don't. There's no requirement that you be on an H-1B visa in order to apply for a green card. However, it can be advantageous to be on an H-1B for specific reasons. So one is the H-1B is a dual intent visa. So many visas, for example, the TN visa, the O visa, the E visa, they don't specifically allow for dual intent the way that the H-1B and the L visa do, where they specifically say that you can be here on this non-immigrant visa, but also be applying for an immigrant visa to stay permanently. And there's, no issues with this. You won't be questioned about it at all. Another reason is that in certain circumstances, if you're staying with your same employer doing the same job, you can travel on your H-1B while your green card application is pending. So for many applicants, if they're on a different visa, once their green card application is filed, they are not permitted to leave the United States. until they've obtained an advanced parole travel document, or they will have abandoned their I-485 green card application. If you're on an H-1B and you meet these criteria of coming back to work for the same employer, you don't need that advanced parole document. You can continue to travel freely on your H-1B without having a period of time where you're waiting for the advanced parole application to be approved. And those advanced parole applications can take several months. Similarly, if your immigrant visa category is backlogged, it's helpful to be on the H-1B because there's, as we discussed in the previous slide, there is a process for extending the H-1B status while you wait for that immigrant visa to become available. So there's a large benefit there if there is no immediately available immigrant visa for you. So what is the green card process after an H-1B? So while you're on an H-1B, an employer may sponsor you for a green card. A very common way this happens is through something called the PERM process. And the PERM process is when the employer will test the labor market in the US to determine if there are any willing, qualified, and available US workers for the position. If none are found, then the employer is going to file a labor certification with the Department of Labor. If that is approved, then the employer can file Form I-140 with USCIS, along with proof that the employer has the ability to pay the prevailing wage that's required, and proof that the employee meets all the requirements for the job. So has the degree, has the experience that were all required for the PERM job. If an immigrant visa is immediately available, then the employee can simultaneously apply for a green card. So you can file your I-140 along with the green card application, or you can get the I-140 approved and then immediately file the green card application with USCIS, or you could apply at the National Visa Center or US Consulate abroad if you prefer. That being said, if you're working in the United States, and you primarily live in the United States, for most applicants, applying with USCIS is going to be the way that they prefer. All right. Do I have to prove that the company cannot find US workers for an H-1B? This is another common misconception. It's not a requirement for the H-1B visa for most employers. So for the PERM, you do have to prove that you cannot find US workers for the position. But for the H-1B, you don't have to do that, only in some circumstances. So there are some H-1B employers, H-1B dependent employers, meaning having more than the normal amount of H-1B workers, or willful violators. So the Department of Labor or the Department of Justice has found the employer committed willful failure or a misrepresentation of a material fact. So for these two types, they must attest that they will not displace US workers, and they do have to actually recruit for US workers for the H-1B position before filing an H-1B petition. That being said, for the vast majority of employers applying for H-1Bs, it doesn't, this doesn't apply. All right. So I believe that we've come to the end of the slideshow, and I don't believe that we've had any questions that have come in. So I want to thank you all for participating today, and we will send you the webinar and the other documents that were mentioned at the beginning of the webinar. Thank you and have a nice day.